Hi, it's Shamian Ao here. Today I will be discussing why privacy and employment are closely intertwined. Number one, employees are data subjects. As data subjects, they are owed duties of protection of their personal data by their employer. As an employer, you should ensure you have the necessary consents for processing employee or other person's data. There may be useful exceptions, however, you should always check if these apply, as these tend to differ from jurisdiction to jurisdiction. Your employment contracts, handbook, and even job application processes should be reviewed for data privacy compliance. You should, wherever possible, develop standard processes for your recruitment, onboarding, and termination of employees across different scenarios. As activities crop up from time to time with respect to managing your workforce and also post-termination, it helps for your HR function to be familiar with applicable privacy regulations. Have clear and easy ways to process data subject rights. For example, updating one's particulars should be as simple and error-free as possible. With requests for access of HR data, you need to be careful if exclusions apply, if the records need to be redacted for confidentiality, or if you can provide extracts that do not contain sensitive opinions. This is especially crucial when an employee is terminated with cause and feels aggrieved. Number two, employees are agents of an organization, whether these be a controller, a processor, or both. As agents, employees are occasionally exempted from themselves being liable under the law, for example, if they're acting the cause of their employment. In other words, their employer assumes liability for the employee's acts or omissions that bring about an infringement of the data law. That said, there could be exceptions. For example, employees holding executive positions and knowingly conniving with a breach. And that could actually end up with them attracting personal liability. The reference to acting in the cause of their employment brings up interesting issues in today's world. For one, what is the scope of this exactly? What happens to individuals who are contractors or gig workers? What would tip the scale between what constitutes a contract of service versus a contract for services? As an employer, what mitigating steps can you take to ring-fence employee risks? Well, at a minimum, you should ensure that your policies make clear what your endorsed practices are. Conduct regular trainings on these protocols too. Enable adequate security, for example, access controls, encryption of sensitive records, adherence to retention schedules, and well-considered incident monitoring and response procedures. If you need assistance in navigating employee-related privacy issues, feel free to reach out, as I would love to help.